Hello and welcome to StudyIQ English, your one-stop destination for succeeding in the civil services exam. And welcome to today's current affairs video where we are touching upon an ongoing debate between freedom of speech and expression guaranteed as a fundamental right in the Constitution on the one hand, and on the other hand is the particular section 152 of the Bharatiya Nyaya Sanhita, which is the modern reinterpretation of the Indian Penal Code of the past. Is section 152 of today's Bharatiya Nyaya Sanhita coming in contradiction with the freedom of speech and expression given to all Indian citizens by our constitution? Why did this issue come into news? Now, this happened yesterday when the Honorable Supreme Court of India gave a decision on August 12th that senior editor of the news website The Wire, Siddharth Varadarajan, and few other members of the Foundation of Indian Independent Journalism, they were all convicted by the government for releasing an article in the newspaper based on Operation Sindoor. But the Supreme Court said that no forced, no punitive, no coercive action shall be taken against these people under the Anti-Sedition Act of Section 152. As the Supreme Court is hearing the appeals of these people involved, a bigger question emerges. The potentiality of the abuse of Article 152 by the government to curb and stop people from expressing freely their views, opinions, and ideas about issues of national, international importance, government policies, and government decisions. If people are booked for making any such writing, verbal statement, illustration, picture, then is it not an abuse of the section 152 that is being called as a very strict anti-sedition law under Bharatiya Nyaya Sanhita? So, Bharatiya Nyaya Sanhita under this section typically says that any act that endangers India's sovereignty, India's unity, security and integrity is punishable. And now Supreme Court is wondering, is the very section 152 unconstitutional? Because anything that deprives the citizens from their fundamental rights should not be allowed. It should not be considered as constitutional. So therefore, for the purpose of our UPSC exam, let's talk about UPSC syllabus, GS paper 2, governance and polity. Let's see what is the relevance of our criminal laws. We used to call them the Indian Penal Code, but from 2023 onwards, we call them the Bharatiya Nyaya Sanhita, the new modernized version of the IPC. But a lot of people are asking that BNS has certain such anti-sedition laws which have not even changed as compared to the old IPC British time laws. They continue to be as strict and as orthodox as the colonial rules. So what is the point of having modernized and created the Sanhita itself? See, if we talk about section 152, it clearly says that any act, speech, writing, action that is against India's internal security, India's unity, dignity, integrity will definitely be punishable, and that will allow the government to restrict the freedom of speech of such an individual or such people who are found engaging in these acts. In effect, it is nothing but an act of criminalizing speech, writing, and action that will incite, that may incite any kind of secession, that is, separatism from the national unity, any demand for a separate country outside the sovereign territory of India. When we use the word secession, let's be very careful and let's not confuse with the word separatism. While separatism is about a group of people or communities demanding a separate state in India, a phenomena that started long back during the 1950s itself, after which we saw Andhra Pradesh coming out as the first state created on linguistic basis. But even after the period of 1960s, we saw repeatedly many different states being created on linguistic and ethnic basis. For example, back in 2000, we had Uttarakhand, we had Jharkhand and Chhattisgarh. And the last state that was created was 2014, that was Telangana from the rest while Andhra Pradesh. So separatism is allowed because the government of India and Indian constitution in part 1 of the constitution permits a reorganization of states. Their change in name, territory, mixing of the area, division of the area is acceptable. But India is a union of states in such a way that the union is indestructible, although the states can be modified in terms of boundary or name. So clearly here, we may permit separatism, but we will not tolerate secessionism because that is anti-national. That is completely a terrorism. So therefore, the Section 132 was created to punish any act which allows for extremism, secessionism, terrorism against India's internal security, its sovereignty, any armed rebellion, any kind of subversive activity which creates fear or dissent in the country. It was not allowed and strictly to be punished under this section of BNS. Punishment could be life imprisonment or up to 7 years long jail term along with a fine. But until the section 152 is covering serious cases of threats to our national unity and security, it is absolutely valid. But today the debate has erupted because it feels like this section has not defined properly that what constitutes the act of dissent or what constitutes the act of rebellion or any threat towards national security. The definition is very vague and therefore it is subject to multiple interpretations. No wonder sometimes simple acts of criticizing the government or any government agenda are also categorized very conveniently by the government as being punishable under section 152 of the BNS. So therefore, until we have a clarity of what do you mean by danger or threat to India's security and unity, it is absolutely illegitimate to be catching people, booking them, and punishing them just because they wrote something that the government did not like, or just because they made a speech which did not go well with the government's agenda. So, accordingly, today, so many acts of journalism, so many acts of speeches come under the scanner. So, now, any speech for that matter, whether it is about India's history, a famous political figure, somebody who is being criticized, somebody who was a national figure, but today somebody in the modern day society wants to criticize that historical figure. That also is now considered as an attempt to endanger India's unity and integrity, which means we do not even have a right to reinterpret history. So this today people are saying that no matter whatever tall claims has the government made, by saying that section 124A of IPC of 1860 is today modernized into section 152 of the Bharatiya Nyaya Sanhita, nothing has changed. It's just a name change. Apart from a change of name, it is nothing because the content, the purpose, the objectives, and the functionality remains the same. Criminalization of any dissent. So therefore, the colonial time sedition law that was created by the British government to punish anti-British agenda is being utilized by the modern day Indian government to stop any criticism against that. And therefore, the article in the newspaper today and the news debates are asking one question. Are we not threatening the Article 19(1)(a)? That's a very crucial fundamental right given to citizens in India, which gives us the right to freedom of speech and expression to each and every citizen. And freedom of speech and expression means the expression could be written, it could be verbal, it could be illustrative, artistic. So it also means the right that an individual in India, a citizen of India, has to express their views through newspaper article, through a podcast, or through any kind of social media post, any other form of communication. By imposing and invoking section 152 for small acts of disagreement, we are defeating the whole purpose of this anti-sedition law. And if you actually interpret the Article 19(1)(a) properly and in detail, we realize that Article 19(1)(a) allows us all kinds of freedom to speech and expression. The only times or the only situations in which there is a restriction on the free speech and expression are these. Either it is when the security of the country is under threat, or if a speech, action, a writing is creating some kind of a public disorder, in case it is creating problems with India's relations with other countries, friendly countries, or if it is immoral in nature, it's threatening the decency, the morality of larger society. If it involves the contempt of court, or if it is about defaming, defamation against any individual, or if it is trying to create violence by either fake propaganda or communal appeals, hate speeches that cross their limits, or it could mean any other act or speech that is against the respect towards India's sovereignty, integrity, unity. Apart from these restrictions that are allocated under Article 19(2) of the Indian Constitution, the broader Article 19(1)(a) is about giving liberty to a modern society like India. But whenever improperly spelled out or misrepresented acts like the section 152 of the BNS come into the picture, they become convenient tools in the hands of the government to suppress the voice of the people in our democracy. So that's the article. And now to the question from UPSC 2021, which asks you that a legislation which confers, which gives on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which of the following articles of the Indian Constitution? The options for you are Article 14, Article 28, 32, or Article 44. Now, this is an easy and direct question, which means if we understand the various articles, the various directive principles, and various parts of the Constitution systematically, their use, their purpose, objective, then many questions in the UPSC prelims exam become quite easy to handle, because polity is one segment where it purely shows your awareness and understanding of various articles, clauses, schedules of the Constitution. And on that note, I strongly suggest you to try to answer the question and post your answer in the comment box. And here I want to end with a great, wonderful news. So here at StudyIQ, we are offering a massive, the biggest sale of the season on any course that you want to enroll into. So you could use the code here on the screen and you will get 47% off on various courses, various study materials that you would like to enroll into. So do not miss the opportunity and take a step towards your success with us at StudyIQ English. Do like, share and subscribe. Thank you.